everyone. Thank you so much for joining. Welcome to today's session on Digital Personal Data Protection Act or DPDP. This is a topic which is moving from being seen as a compliance requirement to becoming a core governance and trust imperative. That's how at least we look at it. Another thing which, and closely related to what I just said is, according to us, and we'll talk a little bit about the consortium that we have put together under the umbrella of which, first of this session is happening, and we'll have series of these sessions. For us, DPDP is not just about regulation, as we keep talking about, like most of the risk practitioners, that anything, that we do, we want to kind of move away from just kind of checking the box kind of exercise. So this is not just about the regulation, but it is shifting from data opportunism to data accountability. That's how we kind of see it as, at this. It also raises fundamental questions about ownership, leadership responsibility, and how organizations build trust with customer and stakeholders in the digital first world, right? And to help us unpack this, I'm delighted to welcome Srinjoy Banerjee, a very good friend of mine, but more than that, he brings deep expertise in privacy law along with practical experience, and he advises lots of organizations on navigating data protection, the privacy, and overall kind of risk management frameworks. His perspective also is where he bridges legal interpretation with real world implementation, because he's very focused on execution and on the feasibility and the practicality of it, which is exactly what organizations need today, because there's a lot of talk happening, but when it comes to implementation, there are gaps that we see. So at Beyond Risk, we see a lot of intent, as I said earlier, but also significant confusion on where to begin and what exactly, should be the first step in kind of going about this journey. To address this, we have formed a consortium, as I just talked about earlier. We have, a law firm which Srinjoy represents, like Sorbis. We have Gain Insights, which is an analytics company. We have Riskok, which is the GRC provider, and we have Vetrix, which is, like the technology provider. The goal is simple, demystify DPDP and help the organizations move from awareness to action. So with this, let's dive into the conversation. Srinjoy, great to have you today for this session.
Thank you, Jitu. It's a pleasure to be here and be part of this session. And I really thank all the participants who have taken their time off on a Tuesday evening to join this session. Thank you. With that, we can
Thank you.
start. Yeah.
Thank you. Yeah. So first question, look, I think I talked about that in the opening remarks as well. Um, the DPDP is being discussed, widely. You pick up, like LinkedIn, you go, there are many, webinars which are happening, like what we are doing. There are many kind of, events which are happening. So there's a lot of buzz around, DPDP. But when you talk to the CXOs, especially like in private, they will say that, oh, you know what, this is another compliance requirement, right? So from your perspective, because you have that vantage point, you work with a lot of clients, you see things on the ground, and you were part of the workforce as well, which was kind of, instrumental in bringing DPDP alive. So from your perspective, and as a privacy lawyer, how significant is this legislation from Indian companies' perspective compared to some of the earlier regulatory frameworks?
Fantastic question, Jitu. I think, and to start off, I would in fact uh, take a step back a little bit and really look at where we have come from. And that will also answer your question on how the evolution has happened. So basically, I think we have been talking about this act and the rules for a long time, and 2019 is 2018 19. We were talking about a report that was placed before the Parliament. There were various versions of the act that came about in 21, in 23, and finally in August of 23, we got this. We got that it was tabled before the Parliament. It was passed by by the by the both houses of parliament, and we this act finally got notified in 25. Now, the the important thing to understand is that uh, the right to privacy is a right that was given in the Puttaswamy judgment, which was as recent as 2017. So we are talking about this phase of 2017 to 2025, 26, wherein we are looking at the act evolving. Now, before the act came about, we had what is the Information Technology Act, wherein there were some concepts of privacy that was there. There were some SPDI rules which is the sensitive personal data and information rules, which primarily formed what was then the privacy aspect. Now, from the compliance mandate that is there, one of the key things that we have to understand is a difference in perspective between how India sees India sees the ad, how India sees privacy versus how the West sees privacy. Now, we we as Indians are very open, and therefore we keep on sharing information here and there. But with the advent of this act and with the advent of the digital age, this concept has had to change, because that's where the data is leaking, and that's how, even in organizations, when we are looking at this, we have to look at this from the lens of uh, a perspective that this act is one of the few acts in our system which affects us both as an individual as well as an organization, and therefore uh, the it's not just another compliance requirement. It will it will actually mean that a lot of action will need to be done by organizations now, because the act has been notified, and the compliance of this act deadline has been put by the government, which is May 27th. So one of the key things that is happening is that we have to look at it from the point of view of how do we build a, a regime in the organization which is an enabler to systems, not just a compliance checkbox. I'll pause here, and you
Yeah.
can.
No, thank you so much for that. So like what I kind of like hear you saying is that one, definitely it's much more significant than whatever version was there previously. Second is like I think I like the point where you talked about it impacts as individuals, and then we have to look at it from an organization perspective but also from an individual perspective, because the whole mindset shift has to happen, right, when it comes to data
Exactly.
privacy. And third thing is obviously companies have to have that regime of where they say, okay, it's not just a compliance requirement, it is much more than that, right?
Absolutely. Absolutely.
Okay,
Very true.
cool, thank you. So my second question is like, now we talk about, you said, regime has to be set up, and, like it's not just a compliance requirement. Many times, in our conversations, we also come across where CXO level people or, like people in the organization, they're treating it, or at least in their mind, they're thinking about this as a IT or a legal issue, right? Some people are saying, oh, like you need to have some good controls around your IT and you protect that data, or you kind of, secure that data. And consent obviously is a big part of it, where they say, okay, it is a legal issue. So they are either kind of talking to lawyers, separately, or they're talking to IT. From your side, from your perspective, how do you see that? Is it like just, in a silo IT or a legal kind of a issue, or broadly, like some people are saying on the other end of the spectrum that it is a leadership and governance issue? So where is the reality? Is it somewhere in between? Is it like a governance issue, or is it IT or legal issue?
Very interesting question and a very valid one. In fact, when I started off my journey as a privacy professional, uh, the that it was like we used to play that game wherein somebody drops a hanky and then goes off. I'm forgetting the name of the game, but basically it was like that. So it used to fall into the clap of the legal and compliance to look at privacy. But the interesting thing to realize is that privacy is not a one point solution or a uh, one department's role. It actually takes a village. So the legal aspect of privacy, yes, the legal team has to be involved in that. The IT aspect, the technical controls, is where uh, the the maybe the IT will or the information security will step in. But the ultimately it is a way in which throughout the organization we have to build up a privacy culture. It is not only uh, if one person is doing, for example, say an information comes to the HR, maybe the employee data comes to the HR. Now, HR department of any organization. Now, the HR department alone will not be responsible for that data. That data will flow throughout the organization, say to the finance, say to other stakeholders. Now, the the idea of privacy and the idea of compliance means that from the very start, from the point of time when it is collected, from the point of time when it is taken out of the system or deleted, we have to take care, and that's what the ethos of the act is, that we have to take care that the personal data that is lying in the organization is has got the measures, has got the security, has got the rights to the individuals. So this entire chain of things has to happen for us to be compliant to it. Now, one of the things that I always say is that when one talks about accountability, the accountability of the data perhaps lies in these parts, which then becomes the sum of the parts. And therefore, a top down approach is definitely one of the major things that is there for the success of any program that we run for privacy. A top down approach would mean uh, that right from the uh, CEO's office, it has to be driven down to every part of the organization, and therefore the the compliance regime will only be successful if all the C-suite plus the people working under them are doing what they are supposed to do. And governance, therefore, is a vital cog, but accountability ultimately uh, sits with perhaps the good way to answer that is that every individual who is responsible for the data is also needs to be accountable for it.
Great. Thank you. So yeah, no, I think you kind of touched upon, the cultural point in the first, when you were responding to the first question. So I hear, like it's not one department's responsibility, it's like everyone's responsibility. Whosoever is using consumer of the data or whosoever is kind of, like touching the data absolutely is responsible and accountable. And obviously, like privacy by design is the right way to go about it, right from when the data enters into the organization to where, like the exit point is. Each stage of that process, we need to kind of make sure we secure the data. And obviously, again, tone at the top, the culture, I think those are the very, very important pieces. Of course, you may have technology and right lawyers and right kind of, all that stuff. But yes, culture obviously plays a very, very big part, and it starts from the top, right? Okay,
Absolutely.
great. Thank you. So, in your work currently, Srinjoy, and we have, I'm assuming, like I didn't kind of go through who all has kind of, like really joined the call today, but there were a lot of people, like who are from MSMEs or startups. I'm hopeful that, they've joined. Um, what are the common misconceptions? And even it could be, like some of the bigger clients as well. One misconception, of course, is that, this is a legal or IT issue, which we just talked about. Are there any other misconceptions people have about DPDP? In your kind of work that you are doing, if you're aware of what those misconceptions are, and if we can, blast some of those myths out in
Yeah,
this conversation.
Le- yeah. Let me see. I think I would say the most common misconception, especially in the small to mid-sized companies, is that uh, we are not we we might be exempt, or we are not really collecting too much of information, so it may not come to us. Now, the challenge to the issue to that is that when you're say dealing with children's data or healthcare or financial data, you may be a, a very small player in terms of your business size or anything, but you may be referred to as what is called as a significant data fiduciary. Now, a significant data fiduciary is an entity which has a higher threshold of compliance that they need to make. So I would say that is one of the most common that is there. The other aspect that I see a lot of is kind of, when do I need to take consent? When do I need to provide notice? Now, in India, unlike the West, in India, the Data Protection Act, as it stands right now, is a consent regime. That means that for every action that you do, for every personal data that you collect, you have to have a purpose. You have to have a way in which you have to tell the user that you look, these are the sets of data that you're collecting, and this is the purpose for which you're collecting it, and then take a consent from that. Now, one of the things that I see quite a lot of is that even my stakeholders, who may be the information security personnel or the legal personnel, even they might not have sight as to where the consent, if the consent is happening at all or not. And that, to my mind, it becomes a major issue when we get down to trying to build up the privacy framework in an organization. The the other misconception, if I can just lightly put it up, is that while the act does say technical and organizational measures, they are not really, the act will always talk about technical and organizational measures very lightly. So if you are an entity, uh, say, who is having sensitive information, maybe your threshold of technical and organizational measure will be higher, where your risk is higher. It'll be higher than what is there for an organization that does not collect. So at no point of time the act is, or the law is trying to say that you have to do everything under the sun. The idea of the law is to drive business. One of the key things that about this law is that it is a driver of business, unlike the Western laws, which are perhaps more compliance centric. This law is trying to drive business, but at the same time, in a compliant way. So
Okay.
these three are the biggest ones that I uh, have come across. And as we go along, maybe if there's something else, then I'll definitely come back to it.
Sure, sure. Just kind of, like if you can elaborate a little bit more on that first misconception you talked about on this, like, companies may not even know, or organizations may not even know because of the data that they have, that they can be treated as, significant data fiduciaries. Do you want to just kind of explain that with maybe an
Sure,
example or so?
sure. So the if I really look at it, the the let me start by the definition of what the definition says. The definition of a significant data fiduciary, while the government has not really defined it particularly, but what they are saying is that organizations that deal with personal data which is sensitive in nature. Now, if I take a leaf out of what the sensitive definition is there in the Act as it stands right now, we are talking about healthcare information, we are talking about financial information, children's data, we are talking about um, the the entire kind of profiling data if somebody's running an organization that profiles people. So in that case, that entity, while they have there are about 10 odd kind of measures that the organizations will need to take. They will need to have a proper compliance, they will need to have accuracy, they'll need to have technical and organizational measures. But apart from that, the significant data fiduciary will be audited every year. Number one, they will have to have a DPO, that is a data protection officer, who will be the uh, go between the board, which is the data protection board, that is the authority that looks after that will be looking after the compliance of the Data Protection Act, and the individuals along with the company. So that data protection officer, the appointment of the data protection officer, audits and assessments are two of the major aspects that a significant data fiduciary will need to take. Now, as an organization, one of the things uh, that we do for organizations is look at the look at the organizations, go into them and understand whether they will fall into this bracket of significant data fiduciary, and therefore our compliance then we will run based on this understanding.
Okay. So this is not about the size of the organization, but the kind of data they are kind of
Exactly.
dealing with. So that's a very, very big, I think in my mind, a big challenge, because a lot of those smaller organizations, and we work with a lot of startups, we are incubated with NASCOM, and we see a lot of these startups having, some amount of sensitive data, and they may not be even aware of that. They need to kind of comply with some of these requirements, right? And they could be bracketed under the significant data fiduciary. I think that's a very big challenge, I'm assuming.
Absolutely, and that's what I think the definition will become important. So when if it's a say a health tech or a fintech startup, uh, perhaps that is an exercise that will need to be done upfront so that we know where the compliance journey has to move.
Okay. Okay. And then just building on this question, Srinjoy, like there's also a lot of discussion about penalties under this act, right? So from a practical standpoint, what kind of failures? Like one is we talked about the significant data fiduciary, and maybe the organization doesn't even know and they don't appoint DPO and all that stuff. But what are the other failures which could expose the companies to regulatory scrutiny or penalties?
Yeah. So good question. I think one of the first ones that will be there will be, I think, the entire consent piece, how the organizations are giving notice and how the organizations are taking consent for that. Now the the act talks about uh, a penalty of starting from 150 crores to 250 crores. Now, there are, uh, if I can put it this way, that there are breaches that are for taking reasonable security safeguards. There are breaches that will be for wherever data principal notice of a personal data breach is not being given. Then additional obligations in relation to children, and the entire piece of any provision that is there, 150 to 250 crores. But practically, the one that I see that may happen more often than not is an individual going to the board and saying that my data is not being handled properly. And therefore, when that happens, then the board on investigation can impose on any of these counts, can impose uh, any uh, any penalty from 150 to 250 crores. Now, mind it that this penalty uh, is for one action. So if there are two
Mm.
actions that are found that say you don't observe the reasonable security safeguards, as well as you don't observe the breach of any other provision, so you are talking about a cumulative penalty of 150 plus 250 crores. So up to. So this is one of the major things that I see. Consent, notice consent not being taken care of, or notice that is very non-transparent, is going to be one of the major things that is there. The the second one is, as I was saying, maybe the complaint not being handled properly
Okay.
is also going to be uh, where the data principal rights have not been taken care of, and say you don't give the right to access, or you don't give the right to of withdrawal of consent, or you don't give the right to erasure. If you do not do that, then also you are talking about an obligation of about 200 crores. So at each stage, each of the compliances that are there uh, will trigger an obligation, can trigger, sorry, not will, but can trigger a penalty of this 150 to 250 crores.
Okay. That's massive. That's
That's
absolutely.
massive. That's massive. And as I said, it's cumulative. It's not, you may have fallen foul in two cases, and then you'll be fined accordingly.
Okay. All right. So, I think before I ask my next question, we are pretty much, I think, yeah, exactly at half an hour from when we started. So, for the people who have joined, if you have any questions, we do have some pre-submitted questions already. But if you have any questions, you can put it in the chat box, and I'll bring it up like in next 5-10 minutes, because we want to leave some time for interaction where you can ask questions, and Srinjay will be happy to answer them. So start putting your questions in the chat box if you want to. Okay, so my next question is, let us now say that, okay, like people are aware of the penalties, and they are aware of, like that they may be significant data fiduciary. So awareness level is there now, like people understand what exactly is required and what are the penalties if they don't kind of do the right thing. Now, what would be your advice if someone wants to start on this journey, right, in the right way? What would be first few steps to start this journey, and what are the common pitfalls which they should be avoiding? What are some of the things which they should not be kind of doing, and they should kind of do it in a different way? So it's a two-part question, Srinjoy.
Okay. So the first is what are the
Well,
first steps, first few
yeah,
steps?
how would you go about it, right? In terms of, like what are the few steps, where like you talked, in one of the previous answers when you were giving, you said like, you try and understand, what kind of data, organizations have, and then you decide whether it's a significant data fiduciary, and then accordingly, then you decide on the design of, like the whole thing. So what are the first few steps, if you as an organization, if you want to get on this journey in the right way, What are those steps, and what are the common mistakes, like organizations are making, and how to avoid that?
Sure, sure. I think the first uh, out of the first few steps is one is get a kind of a leadership buy-in that we have to do this. We have to build this compliance regime. But after that, the first step will be to try and understand the organization setup itself, understand the environment of the organizations, and do the first data flow mapping that is there, which is basically to understand where all the data is flowing before coming to a system wherein you really start building up those consent parameters. And that is what we do, is that we when we go into organizations, we first of all understand, get the buy-in, first of all understand where the data is, understand what the regime is of the organization. One of the challenges, and perhaps answering your second question also, one of the challenges that typically happens is that the organizations are generally running organizations. Now, when we are talking about running organizations, there are a lot of moving parts that are there. There are a lot of legacy. There is a lot of legacy data that is there. You won't even know where who has taken consent, where the data is lying, what are the legacy softwares or the
Mm,
systems that are there. So processes maybe there, but they are broken to the extent that they are not being followed. So this is, I think, when I see the challenges that are there, this is one of the major issues. Now, organizations have come to me, come to us and said that, look, uh, our system is so good that tomorrow I can give you the all the data that you require. And when I ask the simple basic questions, they go back to the drawing board uh, and are not heard for at least 2 weeks after that. So this is because the stakeholders also don't know what they don't know. Because when you are building up a privacy regime in an organization, you have to get everybody on board over there. And when you are talking to them, uh, you'll have departments who say that, look, we don't do anything of this sort. And then we get into the nitty gritties and say that, look, uh, didn't you collect this personal data? Oh, okay, this is also a personal data. One of the major issues in some cases is that even even your uh, even your organizational email ID is, as of now, considered to be a personal data element. Now,
mm,
this very basic fact is something that is missed by organizations.
yeah, yeah.
So, the I think the simple answer to your question is corral whatever data that you have, then see how the data, which of the data paths are under the consent regime, which other data paths are not under the consent regime, who has sent the consent, how's the organization protecting that data. So these are questions that come about as we go along. But to just to put an end to this answer is that it takes time, but it is because we are all living in a world wherein data is just getting stored into in our systems.
Yeah, yeah. No, thank you for this very detailed answer. And I was kind of having a chuckle when you talked about, like, oh, this is also data. People discover as you ask those questions, and they may flatly kind of refuse that. They have anything to do with data, but when you probe, and then things come out. So yeah, very relatable. All right, so we have a lot of questions which have started to
Wow.
come,
Yeah. Yeah.
Srinjoy.
Yeah.
I'll pick, like those questions because that's the whole intent, like people have
Absolutely.
questions. So the first one, I think we have answered, but I'll still kind of read it for you. It's from Mayur. It says, how is the penalty calculated under the DPDP Act? I think we answered that, but I don't know if there is anything
Yeah.
more
No,
detailed.
I would say, Mayur, again, the board and the government will not be, I do not think they will be very malicious on this, but the parameters will be basically on the basis of uh, a couple of things. There will be more as well, but couple of things. One is, uh, if there was a breach, or uh, if there was a loss of data, what have you done as an organization? Number one. Number two will be, how much of it were you able to protect, and how much of it has got lost? And then based on that, they will take based on the volume of data lost, based on the risk of harm that is there, on these varied parameters, they will take a call as to what exactly is should be the final fine that is imposed on the organization. So if a person, or rather an organization, has taken steps and even then it has lost, then they will take that into consideration when they are imposing the fine.
Okay, thank you. The next question is from Nishtha. She's saying, is data minimization realistic in a world driven by analytics and AI, especially when Gen AI models are highly dependent on being trained on large scale data sets? Moreover, I may be wrong, but I think the Act excludes publicly available data. But where do we draw the line between open source data and its ethical usage for Gen AI?
Wow. I think, Nishtha, is it? Yeah,
Yeah.
Nishtha, I think we will have to have another session only on AI and data privacy. But to quickly answer your question, I think, see, the challenge of AI is definitely there. But even in AI, one of the frameworks that is coming up, as the seven principles that we had, the recent AI India summit, and there are particular principles that are there for the use of AI as well. Now, even in that, privacy and transparency, uh, and the right input of the data are key aspects in the principles of AI as well. So I know that this data drive and Gen AI and agentic AI is taking over, but even then, it is up to the organization, that in the organization's database, what is it that they are collecting, which should not be more than what they are supposed to collect. So data minimization principle based is basis on that. Now, to address your second point, uh, yes, it does exclude publicly available data, but there is a caveat there. You cannot use everything that is publicly available and create a model by itself. What will happen is that when you the question that will be raised is that when you are collecting the data, did you have an deemed consent or an explicit consent from the user of the data? So if you find information about me throughout the internet, you may build you have the ability to build publicly a model on that, but that's not the uh, ethos of you as an individual versus you as an organization, right? So therefore, uh, the important thing for organizations to remember is to err on the side of safety. There are a lot of things that are available, but we have to have the proper frameworks that are set up from a privacy and from even your AI policy will have to will play a part there.
Thank you. I think she has a follow-up question as well, although Narhari has a question, but let us kind of finish this off first. So Nishta is again saying, linked to my previous question, if Gen AI models are trained on open source data, who's accountable, the model provider or the enterprise deploying it?
Okay, linked to my privacy, if Gen AI models are trained on open source data, who is ah this is the question that is being uh, debated throughout my network, as well as the even in the AI AI summit. This is a question that is up there. It is a very gray area right now, but the the idea over here is that all the following, all those two will have to be accountable for it. There will be liability that will be imposed on both the model provider and the enterprise deploying it. So the the fact that you have an open source, you have done an open source training on for your Gen AI model does not absolve either the model provider or the enterprise deploying it from the liabilities that ensue from there. So, case in point will become the recent Deloitte case that happened, wherein Deloitte had used an AI to build up a report. So, so that kind of the liability and accountability will have to be divided amongst them.
Okay, thank you. Narahari has a question. He's saying, if a company's revenue is not to the quantum of the magnitude of penalty mentioned, what would happen?
Yeah, that I see that point, Narari. I think the um, again, I do not believe that the board or the government is trying to penalize because they want businesses to grow. So they will take a call based on uh, all those parameters that are there, the volume of data, the risk of harm, and all those things that are there. But what the idea would be to impose fines which the organization can pay, as well as, but at the same time, uh, penalize them for not doing the taking the compliance steps.
True. Cool. Okay, so Ravi has a question. He's saying, does the act apply to housing societies and schools who just maintain some visitor register physical and maintain some Excel and emails? Um, we use MyGate and others, but I do not manage the data. Are we covered by the act too?
Yeah, so that has been one of my one of my go-to points. Yes, my gate, and whenever anybody is putting anything on in the digital format, will become will come under the bounds of this act.
Okay. Next question is from David. He's saying, in the legal world, once the personal sensitive information from the banks or FI is out in the court of law, example, litigation or external counsel, such information cannot be classified as sensitive data, instead treated as public. Is there any guidance in DPDP on such scenarios?
In the legal, once a person sensitive from the bank or FI is out in the court of law, litigation or external counsel, okay, such information cannot be classified as instead treated as public. Is there any guidance on DPDP on such scenarios? Now, the uh, hmm, I will need to once David, I think we'll need to understand this question a little bit better. If you are, if the idea is that uh, personal data being used for litigation, or personal data that is used in litigation, is that the question? Or say I am an individual, my data is used in a court of law, and after the fact, after the case has got over, I am wanting to kind of get my data erased or something?
Yeah, so what we can do is we can let David kind of,
Yeah,
put follow-up
yeah,
comments or,
exactly,
and,
exactly.
and provide clarity. We can quickly go to other questions.
Yeah,
Um, Sainath is saying, what will happen to the data archive which needs to be kept for, say, 5 to 7 years for statutory purposes? The data retention piece is what I think is referring to.
yeah, yeah. So the when you say what will happen to the data archive, which needs to be kept for 5 to 7 years for statutory purposes. So the Act, again, one of the key things over here is the Act, again, will never say that you have to keep the data for X number of years. Say financial data, you need to keep it for say 3 years. But it will say the Act will say is saying rather that you need to keep it for as long as it is required, as long as there is consent and there is a reason for keeping it, unless there is any other law for the time being in force. Now, when we say unless there is any other law for the time being in force, which requires the data to be kept for a longer period of time, then for statutory purposes, we have to, for example, financial data, you have to keep it for 8 years or 7 years as per law. So you have to keep it for as long as that. Now, the important thing over here is that even when you are doing that, there will be some active data and there will be some passive data or data that is not being used. So you have to know the difference and you have to archive whatever is not being used.
Okay, thank you. Ravi is saying in a connected world when we use a lot of service providers, how do we ensure compliance, especially with the third parties?
Yeah. Now, now that is a very, very important question because one of the things that maybe I didn't touch on it when we were talking, one of the things that is happening is that the Act is defining the data fiduciary as the point of compliance. Now, the data fiduciary is in fact supposed to make sure that the data processors, that is the vendors and the third parties and the service providers, uh, they are also compliant to the Act. Now, when we talk about that, there is one thing to say that there is a contract that is there. But one of the major issues that happen is that only by contract you cannot protect yourself or protect yourself from the fines. You have to have a very robust vendor risk management system wherein you are analyzing and doing due diligence on the third parties that you are taking in. And only on the basis of that due diligence are you bringing that organization into your system.
Okay, thank you. And I think a similar question from David as well, although he's kind of giving reference to GDPR here. So he's saying GDPR emphasizes on data controller and processor. The severity is more towards data controller than the processor. Does DPDP apply risk-based approach while sharing to third party?
Okay, I didn't get that question. Okay, where is that question, Jitin?
It is just like above what Ravi's question we just took, right? For third parties, it's just above that.
Okay.
Let me
Yeah,
see if
okay,
I
okay,
can
okay. No, no,
find
I've
it.
seen.
Okay.
Severity is more towards data controllers. Yes. So as I was answering just now, GDPR. So in terms of GDPR, the GDPR, when GDPR talks about data controllers and processors, there is an equal share between a data controller and data processor. They have learned that through a from the 1995 directive, wherein they had the regime similar to what we have right now, wherein the data controller was the key, and the data processors only acted on behalf of the data controller. But uh, now, in terms of the DPDPA Act, the data controller or the data fiduciary is the is the is the organization that is responsible for the data. While we do say that while we do talk about a risk-based approach while sharing data to third parties, one of the key things over here is that yes, you have to uh, have, as I said, a proper due diligence and a proper setup of a contract. Have your data processing agreements if you are transferring outside to a third party outside of the country. Have your data transfer agreements. So all the compliance modules are tuning towards having a proper ring fence uh, around the vendor.
Okay, thank you. I think David has come back
Yeah,
with, some clarification on his question. He's saying banking customer is either sued or suing the bank. The individual personal data is shared by the bank to the court of law on lawful basis. In such scenario, individual data becomes public when the matter is announced in the court. Does it still consider as sensitive data in DPDP?
yeah, and the I think David, I thought as much that that's what you were asking, but the as of now, jurisprudence has not been set. But from the little cases that have happened, for example, a film actor um, kind of managed to get his data kind of deleted or at least blacked out from these cases. So I think the jurisprudence is heading towards that even if you have a um, a scenario wherein your data does become public, uh, as per the DPDPA, I'm sure that there will be kind of cases that will lead to a situation wherein some of these informations will fall under the right to erasure or right to withdrawal of your consent, and it will it will be kind of blacked out. But
Okay.
uh, right now, this is still under jurisprudence, so I will not be able to answer it right away. But uh, it does right now. DPDPA does have loopholes that are there, which kind of keeps this data public.
Okay. I think we have time for maybe one or maximum, like, two questions, maybe one. Ravi Shankar is asking, wonder how products like Lucia will survive. So I just quickly Googled what Lucia means. I was not aware of what Lucia is. It's some B2B database, B2B data intelligence platform used by sales, marketing, and recruiting teams to find and verify contact information. So he's basically trying to understand how products like Lucia will survive because
Yeah.
there's a lot of them.
So analytics and performance, even your Google Analytics, your Adobe, the counterpart of Adobe, um, they will have to have the proper setup, and organizations who use them will also have to have the proper setup in terms of uh, the basically the works, the notice, consent, uh, the uh, the ability for for that profiling to be done of the individual. So whether whether your whether the profiling is being done or not is the first step, and then if they are doing a profiling now, um, to Nishita's point, the since the profiling does sometimes fall under AI, all those considerations will need to be made. Um, Products like Lucia will obviously will need to navigate this kind of a compliance regime that is there, because some of these organizations have come to us also. So um, we'll have to do it kind of smartly. Let me put it that way.
Okay. Okay, I think we'll just take one last question, Srinjoy. This
Yeah.
is from Ravi. He's saying, can we use analytics ready data framework that could help in stripping personal identification and thus use the data for AI? probably anonymization of data, I think is what
Yeah.
Ravi, your
So
point.
yes, absolutely. And Ravi, to your point, if we are able to achieve kind of an anonymization of the data. So if you really look at it, if just to dumb it down a bit, to say that anonymization is a technique by which we have reached a situation wherein the personal data uh, does not become personal at all, and it is absolutely non-personal data. If we are able to achieve that framework wherein there is no personal data, a personal element around that data that is there, then we are actually taking it out of the scope of the DPDPA. And if and when we do that, then we can definitely use the data that is remaining as a means for functioning. So that's a case that um, we are looking at to see how it can be done that way.
Cool. Thank you. I think this was wonderful. So much of learning, and obviously we'll, as next step, like as we always do with our master classes and these kind of webinars, we'll send the summary across to all the people who attended the session. But I've taken some notes, right? So one thing is this is absolutely significant, thing which has come. We can't treat it just as compliance is what we talked about. Obviously, we have to look at the impact both from an individual and organization perspective. We have to think about the whole regime, in a very different way from a mindset perspective. We talked about penalties. We talked about some of the misconceptions. We talked about what are the steps you can take to kind of, start this journey. And I think some really wonderful questions from the audience as well. So thank you, everyone. But before you go, I we will just kind of, like share a small survey, which will help us understand, what is out there, in your minds, and what is kind of triggering some of these thoughts, on how you can comply with DPDP. It's a small survey. It won't take more than 10 minutes. You can do it at your leisure. So if we can share, Rani, the QR code, and you can, use your mobile phones to, look at the survey using the QR code, or we'll send the link as well later on. In the meanwhile, Srinjoy, thank you so much for your time. I know these are very, very busy days for you, and we got you to come here and talk about what DPDP all means and demystify hopefully some of the things. So thank you so much. Thank you all the viewers, all the audience, and thank you to our partners RiskHawk, Gain Insights, LexOrbis, and Vetrix. Thank you, everyone. And this is, on your screen, you can see the QR code. Please take that survey. It is important for us to then kind of, see what kind of questions are in your mind, which we can address in our next webinar.
Thank you, Jitu. Thanks everyone for being part of this session. It was as insightful. I hope it was as insightful for me as it was for you.
Absolutely, absolutely. And we'll, for the audience, we'll have series of webinars, where we
Absolutely.
try to demystify, and what needs to be done from DPDP perspective to make you compliant, to make you kind of, really see it as a significant way, or change the way you kind of, do your business. So just stay tuned, follow our LinkedIn page, follow our, like kind of partners LinkedIn pages. There'll be more webinars coming. And if there are any questions, like which you want, any particular subject or any particular aspect of DPDP which you want to kind of, get help on, do reach out to us. We'll try and get that, into our next webinar. Thank you so much. Thanks, everyone.
Thank you. Thank you.
Thank you. Bye.
You.
Right.
Thank you all.